Hi everyone, you're watching the Virtual Amicus and I'm Jay Lodha. Well, whoever has been following the French Open 2021, my sympathies with you. Well, we just lost Nadal. No, Nadal is very much there, but then Nadal lost to Djokovic. Really sorry for that. But in India, of course, cricket is more than just a sport. Not as big as tennis, probably not as tennis is probably not as big as cricket. But then cricket is again a religion in India. But back in the 90s, that was a time when it was penetrated by a number of problems. There was a problem of gambling, match fixing, and it had virtually sabotaged everything. So sports law, what is the first thing that comes to your mind when I say sports law? Is there a codified law in the country? Is it a part of a concurrent list that enables both the center or the state governments to pass or enact laws? So just to give you all a brief introduction, corruption takes place at all levels in the event of a sport. It could be in the form of betting, it could be in the form of gambling, and match fixing are certain among the other integral factors that are contributing particularly to corruption. Now, even in sports, in the event of sports, big or small, there have been continued be subject to match fixing, subject to betting. But when does betting become acceptable to an extent, or when does it lead to a match fixing that becomes even more problematic? Now, there are certain landmark Supreme Court judgments, like the Z-Tel films, if I'm not wrong, which is the Magna Carta of the Indian sports law, wherein the dispute that arose and the issue that was there before the Honorable Supreme Court of India is that is Z-Tel films, the aggrieved party, can a writ petition be maintainable under Article 32? Because as far as I can recollect, the question in this case was BCCI's arbitrary termination of broadcasting rights agreements with Z-Tel films. So that's again one of the most landmark judgments in this field. So today we have with us Mr. Vedant Agrawal. He's a young, dynamic practitioner. He's practicing before Honorable Rajasthan High Court, Jaipur bench, and he will deal with a topic which is very interesting and that attracts all the viewers' attention. Just to give you all a brief introduction about Mr. Agrawal, he graduated from Jindal Global Law School in 2017, and since then he's been practicing at Honorable Rajasthan High Court, Jaipur bench. And even while in law school, he was keen to make a career in sports law, which is amazing. He's one of those few lawyers that I've come across who actually spoke about sports law even in his law school, which is amazing to hear. And still plans, and I repeat, still plans to take it up eventually as the field keeps growing at a rapid pace with the development of sports in India. And he has a plethora of publications to his name, and one of them being Game Set Intellectual Property Rights, where he got a publication done in the Journal of Sports and Entertainment Law of Karnataka State Law University. Then he's also assisted Advocate Shivam Singh, Advocate Supreme Court of India on a sports law module. And these are just these few achievements that we could extract and pull out. Thank you so much, Mr. Vedant Agarwal, for choosing this one topic that is perhaps everybody's favorite here, and everybody can relate to this. Sports law, is there even a law that governs sports in India? So we all are curious, we all are looking forward to this session, and the stage is set, the floor is yours, over to you.
Thank you, Jay, for the introduction. So today I'll be covering sports law from the Indian perspective, right? And whether there is, like the right questions you asked, whether there is a codified law in India, and how do people even go about sports law in India? Is there even a practice called sports law in India? So let me just start with like what is sports law in general first. So how people define it in the traditional context, it's like sports law is amalgam of various disciplines of law, such as competition law, tax law, contract law, etc. in the context of sports. It includes policy, regulation, statutory laws that govern athletes, sports federations, and sports in general. However, this is considered to be the traditional take on sports law worldwide. The current view of the established personnel in this field is that it is a law in itself, and that as a field is growing as a growing body of precedents and statutory law. But if we talk about India, we are lacking a statutory law, we are lacking precedents. So it is still at a very nascent stage, and it is still a very developing field as far as India is concerned. But if we look at it as an international concept, we have Court of Arbitration for Sports that governs, that was set up by the...
Yeah. Sorry for interruption, but if you could just slightly increase the font size so that it's...
yeah, sure.
Thank you so much. Thank you.
Yeah, I think it would be better now.
Perfectly fine. Please go ahead.
Yeah. So the as far as India is concerned, like I said, it is still at a very nascent state, but at the same time, in the international context, it's a growing field, and it cannot be ignored that it is growing at a tremendous pace. And we have like authorities like Court of Arbitration for Sports, which was set up by the International Olympics Committee, which is there to settle the disputes which the athletes and the federations face within themselves. So now there's a general confusion with regards to whether sports law is a concept in its own or it's sports and the law. So for me, the answer to this is very simple. Sports law has to be a discipline of its own and cannot be termed as sports and the law. The context in which an act, so why it's sports law is because the context in which an act that has become subject to law regulation has to be interconnected with sports. So I'll give you an example. So right now, Sushil Kumar, the former Olympian and a two-time Olympic medalist, is facing a trial for a murder. So we cannot say that just because he's a sportsman and there is a certain aspect of law which is coming into the picture, it is sports law. But if we take the case of Eric Cantona, who's a retired Manchester United player, he was infamous for kicking a fan who was sitting in the stands because the fan abused him while he was coming off. So that incident has to be seen from the view of sports law because it was committed during the game and it was an incident involving a fan. So that is so it has to be sports law and it cannot be sports and the law. Very famous professor from George Washington University, and she graduated from Harvard University, Professor Burlett Carter, has opined that the historical conception of sports law within the general realm of legal matters, the treatment of this field is as not on par with other forms of legal practice, derives from a general assumption about the nature of sport itself and the athletes who participate in it. The notion that sport is not like business, it is merely entertainment. But what she's trying to point out here is that sports nowadays is more like business. It cannot be seen as just a mere entertainment form. Recently, sports have become, the various leagues have come into the picture, domestic leagues, international leagues, and it has become a proper business for a lot of players, and it has become very much important for the athletes and the sporting federations also. So it is not just mere entertainment anymore. The competitiveness and the involvement of a lot of sponsors, broadcasters has made it a business in full flow. So now we'll address whether there is a need for sports law in general. So like I said, over the last 2-3 decades, sports as a field has seen a massive uprising, even in Indian context. Almost every sport has a domestic league tournament being organized with international participation, be it individual sports or the team sports like cricket, hockey, football, kabaddi. With the uprising, there has been a need to protect rights of every party that is involved, whether it is the athletes, the organizers, the franchisees, the broadcasters, or anyone that can be a stakeholder to the event in general. Every element related to sports has developed a huge commercial value, and that the stakes around the sports have increased substantially as a result. With the increase in the commercial value of sports, there has also been an increase in the usage of terms like image rights, sponsorship, intellectual property rights, broadcasting rights around the sporting field. So, like if you talk about Cristiano Ronaldo in the current scenario, his image rights fetch him more money than his general contract with his club. So these things have also come into the picture, like Gareth Bale trademarking his celebration. So intellectual property rights has also come into the picture. And this also forms the part of sports law in the broader context. While the sporting industry has seen a commercial boom, there still are certain issues that plague it, such as match fixing, doping, contractual disputes, poor wages, delay in salary payments, selection harassment. All these things also form part of the sports law in general. So, and because of these things, whether it is the contractual relationship with the agent, with the franchisee, the image rights, the sponsorships, the fixing, doping, contractual disputes, poor wages, all these have made the need of sports law imminent. And that is why with the leagues, a lot of contractual contractual lawyers have come into the picture. They have established a practice for themselves. Sports law has become very much prominent in India, not as prominent as I would like to see, but it is still at the pace where I see in at least like half a decade or so, we would see sports law as a practice, as a practice that people strive to practice in. And one of the main reasons why it's developing also is because we have to realize that in the athletes in current scenario, even today, they are made to choose between sports and their studies. There is not a comprehensive program where they can pursue their study also while giving sports prominence over their study curriculum. That's how Indian education system works. And there's lack of flexibility, and as a result, the representation of athletes take precedence. And one cannot expect every sports person to be well read and understand each and every contractual or legal term. So there is a need for sports law in general in India, and like I said, it will come into the picture in half a decade or so, and we will see people striving for it. So in a Supreme Court case in 1991, it was a very good take of Supreme Court, like how they pictured it and how they said it. In some of the recent Olympic Games, the performance of small states has indeed been excellent and laudable, while the performance of a great country like India with world's second highest population has been miserable. So to improve everything, there was a need to bring in a policy that would help the sporting picture of India get better. So before I move on to the rest of the presentation, it is important to note some key terms like IOC. I would be referring to short terms as IOC would be International Olympics Committee, WADA would be World Anti-Doping Agency, CAS would be Court of Arbitration for Sports, SAI would be Sports Authority of India, NSFs would be National Sporting Federations, and NADA would be National Anti-Doping Agency. So what are national sports federations is also very important here. The national sports federations are responsible for organizing, developing, and coordinating high-level sports. They identify players to represent India in the particular sport and coaches to supervise the Indian sports. NSFs are autonomous bodies and oversee affiliated state level and district level associations. The NSFs are affiliated directly with the international federation for the particular sport. So suppose there is the Boxing Federation of India. It would be associated with the International Boxing Federation. The BCCI would be affiliated with the ICC, and the list goes on. And the Indian government has a very little direct role to play in the functioning of these federations. The government can indirectly influence the working of these national sporting federations by not according them recognition. As introduced in 2010, the NSFs have to submit a required document to the government every year in order to keep their recognition. So the government is trying to be involved, but it is not the ideal scenario where the government should be involved in this case. They should, although they should make rules for the national sporting federations to function, but they should not get involved in their recognition and their derecognition. That should flow from the international context. That's my take on it. So the Indian Olympics Association, the Indian athletes first competed in the Olympics in 1920. Even though it was still a colony, Indian athletes participated on equal terms with athletes from other nations. The responsibility for preparation of athletes and their participation in Olympics, as well as Commonwealth and Asian Games, lies with the Indian Olympics Association. The IOAs help in the performance of the national sporting federations, which select the athletes based on their performance. And this is very important. So the IOA in 2011 set up an 8-member Indian Court of Arbitration for Sport. However, this court has still not seen the light of the day. The members were selected then, but it has not come into function as of now. Now, a very important part of sports law is sports governance. And the governance of sports in India flows from, let's first talk about who governs sports in India. So as per entry 33 of list 2 of Schedule 7 of the Constitution of India, the states are empowered to regulate and promote sports in India. However, it was proposed to move sports to the concurrent list by the National Sports Policy of 2001. various states have formulated individual acts to regulate sports within their state. Even Rajasthan has a sports act, Himachal Pradesh has a sports act, but these acts are very old and they still need a lot of development. And there's not very much there's not a lot of litigation, and they do not help solve the litigation that arrives from these acts. So there has to be a development in this scenario as well. However, it's clear that the central government also has a significant role to play given the importance of sports, especially at the international level. The debate as to who is empowered to legislate in matters relating to sport is still ongoing and has posed some problems to recent attempts to pass national legislation in sport. So national sports policy came in 1984 first, then in 2001. National Sports Development Code came in 2011. Then there was a draft development bill in 2013. And then there was a prevention of sporting fraud bill in 2013. None of this has seen light. There have been various attempts to codify a national sports law or a national sports policy, but it has not come into the picture because there has been a litigation revolving it, whether the Union of India could have made a law when the subject falls in the state list. So there has been a numerous litigation that has been pending, and none of these codes have seen the light of the day till now. So it is while India wants to regulate on these matters, they are still unable to do so. So, and the proposition that came with the 2001 national sports policy has still not been the sport should be moved to concurrent list has also not seen the light of the day. So what is national sports policy? So the history of national sports policy can be taken back to 1984 when the policy was led in the Parliamentary House. The aim of this policy was to improve the very standard of sports in country. The objective of the national sports policy was to develop infrastructure, integrate sports with education, access of proper and high quality equipment and training of sportsmen, development of national sports federation. This was the aim of the 1984 policy. And in 2001, they realized that the 1984 policy was still incomplete and needed revision. So they revised it. And then they said that the national states policy requires central government, state governments, Indian Olympics Association, SAI, NFL, national sporting federations to coordinate their working to strive towards reaching the main objectives of the policy. And one of the main objectives of the policy was to make sure that we perform well in the Olympics game, we perform well at the international level, we secure gold medals, silver medals, bronze medals, our tally goes high. So all of this was trying to be achieved by the national sports policy. And it is a shame that it has still not come into the picture, even after repeated attempts. And one of the key features of the national sports policy was that every 5 years it will be revised. But after 1984, the first real visit to it was done in 2001. After 2001, it was done in 2007. After 2007, a draft bill came into the picture, and this whole policy was brought under it, but that has also not seen the light. So there have been various attempts, but they are failing again and again to implement the sports policy or the sports development code. Then the sports development code in 2011, Ministry of Youth and Sports Department of Sports adopted the development code. The main objective and the intention was to bring the National Sports Federation under its ambit, even though they were autonomous in nature. So certain sports federations did not want to comply with the sports development code in toto, and certain sporting federations thought that certain aspects of this development code, like the one of the age that the retirement age would be set at 70, was they thought that through this development code, the Union of India was trying to overachieve the objective, and they were trying to make their lives tougher, because what the sporting federations did was they associated themselves with the international sporting federations, and their idea was to follow the same principles as the international federations. And as a result, because of this involvement, there was a time when the International Olympics Committee suspended the Indian Olympics Association as a federation, because they thought that the central government was getting way too much involved than they were required to. But the Honorable Delhi High Court, in the case of Indian Olympic Association, when they challenged the Sports Development Code, ordered different, there were 2-3 different sporting federations that became a party to it to comply with the same. They said that you have to comply with the Sports Development Code, even though it had not come into the picture. If it comes to the picture, then you will have to comply with the code. One of the major developments that the code was bringing in, it was making the Court of Arbitration for Sports mandatory as an adjudicating forum. And if that would have been achieved through the Sports Development Code, then India's sports law scenario would have changed immensely by now. But again, that could not come into the picture because the Sports Development Code in total did not get the affirmation. Even the draft bill did not get the affirmation, and it seems like the government is still sitting on it. So, but there have been some, because of the Sports Development Code, at least there has been some movement towards the positive side in the sporting industry. There has been, so the NSFs have been availing government grants as public authorities under RTI. So now they fall under the RTI. Now there's a very key distinction here. So if we look at the BCCI still does not take funds from the government's grants. So because BCCI is a rich board, it has its own fund, it manages its own funds. So they do not fall under National Sporting Federation. And as a result, they enjoy certain privileges, which I'll be talking about later. So introduction of annual recognition for NSFs, implementation of age tenure limits of office bearers of NSFs, notification of NADA anti-doping rules, introduction of guidelines for prevention of age fraud in sports, prevention of sexual harassment in sports, holding of fair, transparent election in national sporting federations. So again, age fraud is a very, very important topic to talk about when we are talking about sports law in general, because if we look at the situation in India, we have people aged over 21 playing under 17s, under 16s, because they fake their verification cards and they try to use it for their advantage to make it to the national teams. Now, there is a dispute channel in India, which is again a flawed dispute channel, because there is no uniformity between different sporting federations. So the first forum is always the forum of first instance, and some of the sporting federations have codified the rules and regulations for the forum of first instance, but at the same time, there are certain sporting federations which have not done anything, and they themselves preside over it. They do not even have a neutral member presiding over it. Now, so if lucky, then certain sporting federations have an appellate authority, and some sporting federations do not have an appellate authority. So, and in that case, then you have to directly appeal before the High Court. And if there is an appellate authority, then you have to go through that and then appeal before the High Court and so on. But what happens in certain scenarios is, like I'll be talking about those cases also. There comes a time where even the Supreme Court has said, or the Delhi High Court, they both have said that we will not get involved in the sporting federation's matter. It is up to the sporting federation to choose or reject a player. And we will just see if there is any patent illegality that is coming to the light. If there is not, then we will leave it on the sporting federation to decide their matters. So that is why the Court of Arbitration for Sports becomes very important, and which is the main adjudicating authority if we consider all over the world. The Court of Arbitration Sport is an institution independent of any sporting organization which provides for services in order to facilitate the settlement of sports-related disputes through arbitration or mediation by means of procedural rules adapted to the specific needs of the sports world. Any disputes directly or indirectly linked to the sport may be submitted to CAS. These may be disputes of a commercial nature or of a disciplinary nature, following a decision by a sports organization. Any individual or legal entity with capacity to act may have recourse to the services of CAS. These include athletes, clubs, sporting federations, organizers of sporting events, sponsors, and even the television companies. So they cover the broadcasters also. And judicial recourse to the Swiss Federal Tribunal is only allowed on a very limited number of grounds, such as lack of jurisdiction, violation of elementary procedural rules, or incompatibility with the public policy. Now, what is important to note here is that CAS only comes into the picture when you have a contract with the other person that in case a dispute arises, we will settle it through CAS. CAS does not come into the picture in every scenario. And that is why when the policy suggested that they will implement an Indian Court of Arbitration for sports, it was a, and even they would make Court of Arbitration sports, which is the international forum, mandatory, one of the options on the mandatory adjudication options. So it was a very promising feature of the code that was coming into the picture. However, because of the flaws and because how the laws are passed in India, the whole procedure has got delayed. And now I'll show why through certain cases, why the Court of Arbitration for Sports has been so functional, and it has received the plaudits all over the world. And they see it as, the athletes especially and the sporting federations see it as like savior for them. So there are certain case studies. I'll talk about the curious case of Luthi Chand first. Luthi Chand is an Indian athlete, a track and field athlete in particular. She was dropped from the Commonwealth Games 2014 contingent by the Athletic Federations of India. The main ground for dropping her was hyper. Now, what is hyperandrogenism? Hyperandrogenism is when a female body produces male hormones, that is testosterone, to an excessive level. They classify it as a case of hyperandrogenism. And the International Athletic Federation's guidelines provide that an athlete with hyperandrogenism would have a competitive advantage over her peers. This was prior to this case came into the picture. So they said that if she's producing male hormones naturally, then she would have competitive advantage over her peers. And that's why she obviously, because of as a result, she got baffled and she challenged the guidelines before the CAS. Now, she raised the ground of discrimination as she has no control over hyperandrogenism. So it is her natural occurrence and it comes naturally to her. It's not something she's injecting into her body. So that was one of her grounds. And the second, and as a result, the CS opined that the regulations were discriminatory as no regulations required men to be tested for hyperandrogenism. So they said, if you tested men for hyperandrogenism, and if one male's body produces more testosterone level than another male's body, then that is also competitive disadvantage. But if you while you're talking about a female body, then why are you comparing and why you are testing them for hyperandrogenism when you're not in comparison, you're not testing the male candidates for the same. And the CAS also opined that it was difficult to prove that the advantage men get over women due to high testosterone level is the same as in the case of women with high androgens compared to other women. The panel further stated that it was almost impossible to say that the advantage a woman gets in the case of hyperandrogenism is greater than the advantage an athlete would get with better training and nutrition, etc. So suppose an athlete like Usain Bolt comes from Jamaica, but another athlete from USA, they both will have different sets of training. And we could possibly say that the athlete coming from the United States of America is coming with a better diet chart, with better nutrition chart, with more facilities to train himself. So they said like hyperandrogenism if you compare the advantage a woman gets because her case falls into hyperandrogenism, you cannot compare those two cases because there's no data, and it would be impossible to say that one person who with hyperandrogenism is getting more advantage than a person who merely because they got better facilities and better nutrition, that advantage and the advantage because of hyperandrogenism cannot be compared. And as a result, they said that it was discriminatory. And today, in 2016, she secured Rio Olympics qualification also. And today, she's one of the most celebrated track and field athletes in India, and she's also the only Indian athlete to secure a gold medal in an international competition. So, like I said, CAS was a savior for her. And we know how short an athlete's career is. They probably last for like 14 years, or if they're lucky, then probably 18 years. But during that span, if they are banned for 2 to 3 years, we need faster resolution. And Indian courts, in fact, any court system would not provide that faster remedy. And the CAS has a timeline to it. Like they have to resolve the dispute between 6 months to 12 months. So CAS is very important to the sporting industry. and the sports law industry, and for the athletes, and for any stakeholder that is concerned with sports and sports law. Another case was of Becky Scott. She was an American athlete, Canadian athlete, cross-country skier. So what happened in her case was she was competing with two Russians, and all three of them were subjected to doping test, and at that relevant time they tested negative for doping. But eventually, when the other two Russian skiers were contesting in another event, they tested positive for doping. So as a result, in 2003, the CAS held that those two Russian athletes would be strapped away from their gold and silver respectively, and the Becky Scott, the Canadian athlete who received bronze in that event, would be given the gold medal. So this was the first time that because of court ruling, a person was getting the gold medal. Again, like just showing why CAS is important to the sports and the sporting industry in general. Now, another case how I would talk about how torts come into the picture in sports law. So during the IPL 2012, Chris Gayle hit a six that showed up in the stands and ended up hitting the goal. Could that girl have claimed a tort claim against Mr. Universe? Imagine a scenario where the ball crossed the stadium and hit a car that was passing by. Unaware of the match and who was batting, would that claim be valid in that case? Apparently, the IPL tickets absolved Mr. Universe and his team for any tortious liability vis-a-vis the audience present in the stadium. Irrespective, there has been a settled precedent from 1951 that is being followed all over the world. In the case of Bolton versus Stone, House of Lords opined that any cricketer, the case talked about a cricketer who hit a ball across the stadium, it crossed the fence and hit a person who got injured severely. So in that case also, they said that no tortious liability would arise because the stadium did their part by building the fence, and they could not have foreseen whether there would be basically for them, while with building of the wall, they thought that they resolved them of any responsibility they had of protecting the citizens that were not involved in the game, or the audience that was not involved in the game. So even in such a scenario, the tortious liability does not come into the picture. But let's talk about a contact sport, like for example boxing. And we know what Mike Tyson is famous for. Mike Tyson bit someone's ear while boxing. Even they say, like, even in that case, when you are agreeing to be a part of contact sport, you cannot claim as a fellow athlete, you cannot claim a tortious claim against Mike Tyson also for biting your ear off, because when you signed up for that event, you were aware of the risks you signed up for. So this is just me showing how torts would come into the picture in the context of sports law, and in what cases it would not be a valid claim. But also, by these examples, we get a picture of what cases could be a valid claim, where you do not have any direct connection whatsoever and the authorities themselves are at fault. You probably would have a valid claim. And if the act of the other person is completely out of the sports, and then he attacks you or causes you grievous hurt, then also it would be a valid claim for the tortious liability. But this is just in context of these two examples. Now, another interesting scenario where all of us would remember, probably, there was a league in India in 2007 called the Indian Cricket League. This was the first T20 cricket tournament that was being conducted in India. And the BCCI used their dominant position to stop them from functioning, because they were very well aware of bringing an IPL. They had all the plans laid down. So they wanted to stop another competition from growing up. So they used their dominant position. They banned the players from ICL. They also made the access to infrastructure uneasy for the ICL organizers. So the ICL organizers went to the Competition Commission of India and they sued the BCCI. The CCI actually eventually it went to the Competition Appellate Tribunal also, where the matter was referred back to the CCI, and the CCI, it was requested by the compact that you please hire a investigative authority and look into the matter properly. Even then, the CCI found BCCI guilty of abusing dominant position after thorough investigation and slapped a fine of 52.24 crores, which is, in my opinion, pennies if you compare how big the IPL has become. But what is important here is, like, if we think about BCCI is a federation that is the authority to govern all the competitive cricketing events in India. And once you are an authority that is governing all the competitive cricketing events in India, you have the authority over the over making such decisions of banning one tournament or making the players that are contracted to you not available for that tournament. BCCI does that by stopping players from participating in Big Bash League, the Pakistan League, the West Indies League, the Sri Lankan League, or even the domestic county cricket that is played in England. To participate in these tournaments, you have to seek special permission from BCCI. So was that really abuse of dominant position? That is to be seen. But this is just an example to show that competition law also comes into the picture of sports. So I'm trying to build a case where how torts, competition law, and all these law together compared with the involvement of sports make sports law a field in total. We talk about intellectual property now. So athletes have started to understand that certain unique moves they pull or what people associate with them could have a potentially prolonged commercial value. So suppose today Cristiano Ronaldo has developed a brand around himself, Roger Federer has developed a brand around himself, CR7 runs his hotels. So they are very well aware that what they achieve during their sporting career could, and if they make a brand around themselves, they could have potentially prolonged commercial value. So intellectual property is also coming to the picture. So now Gareth Bale tried to patent his, like I said, I had given the example before also. Gareth Bale had this celebration where he just did this with number 11 coming into the picture in the middle of the heart he made with his hands. And he patented that move. It was called 11 of Hearts. And experts reported that Gareth Bale could take home £3 million just because of the commercial value of his celebration and different brands approaching him to let him access the 11 of Hearts for jewelry, for garments, etc. So as far as trademark and copyright is concerned, it's still fine, but there has been a critique against the intellectual property in context of patent and trade secret position, that the associations and federations themselves have banned athletes from claiming such protection as it would hamper the game in general. So suppose there is a pitcher in baseball who has a particular technique of pitching the ball, and he tried to patent it and he actually secured the patent. However, the judgment got reversed by the higher court. But imagine a scenario where such an act could help the overall sport in general get better at pitching. Or there was this in long jump, there was this landing technique by a person. If he had patented, it could have harmed every other athlete because that technique was considered to be the best technique to land safely. So if he had gone for the patent, it could have harmed the sport in general in the long run. So that's why the associations and federations are against the patent protection and trade secret protection. However, in some cases, courts have granted the patent again in respect of the very particular technique if they can describe it in a descriptive manner. Now, why India needs a comprehensive sports reform vis-a-vis sports law? I'll talk about a scenario which happened in 2016. Sushil Kumar was dropped from the Indian contingent for 2016 Rio Olympics by the Wrestling Federation of India on the grounds that Mr. Yadav, that Narsingh Yadav, had a higher quota. This quota was set up by the WFI itself. They thought that because he had won an event in 2015, he had a higher quota than Sushil Kumar, and as a result, he deserved to secure the Olympics berth over him. But Sushil Kumar took the situation to the Honorable Delhi High Court, requesting a fair trial. He said that give me a trial, let me fight Narsingh Yadav. If I win, I'll go to the Rio Olympics. If he wins, he goes to the Rio Olympics. As the circumstances suggested, that no fair trial was conducted for one wrestling spot in his category. So Sushil Kumar, again, he was 2 times Olympic medal winner, not gold, silver, once bronze and once silver, but he was a 2-time Olympic winner. And he wanted to go. So he said, like, just give me a trial, let me fight him out. If I win, then let me go. But the court took a narrow view and refused to interfere in the matter, opining that The National Sporting Federation knows best. So the situation got worse when Narsingh Yadav tested positive for doping and accused Sushil Kumar's camp for adulterating his food. As a result, NADA overturned the punishment by holding that Yadav was not at fault. So NADA, being National Anti-Doping Agency, they said that clearly Sushil Kumar tried to sabotage Narsingh Yadav, so we won't find him guilty and we will let him compete. But WADA took this situation to the CAS ad hoc division. Ad hoc divisions are created in case the tournaments are near, and they decide only on those particular matters. So ad hoc division was created for the Rio Olympics, which reversed NADA's sabotage defense and banned Yadav for 4 years. They found that Yadav could not produce sufficient evidence to overturn the judgment. And that's why he could not absolve himself of his responsibility to prove that prove otherwise, that he was not guilty of doping. So a similar fair trial issue was raised by a female boxer before the Boxing Federation of India, accusing them of cancelling the trial at the last moment, deciding to send Mary Kom to the World Championship, even though the complainant had an excellent year to back her selection. So she had won a couple of tournaments internationally, and she said, let me fight it out at least with Mary Kom. She's my idol, but even otherwise, I deserve to go ahead. And if she deserves to go ahead, then she'll beat me and go ahead. But because of the opinion Delhi High Court had already taken over, what NSFs do is their own prerogative. The narrow view got obviously, even in her case, the narrow view was implemented and she lost her spot. So I believe that if the sporting tribunal, like the Indian Court of Arbitration for Sports, existed, then the result of plea would have been substantially different, because they look at as a sporting event. They look at NSFs as whether they have done right or wrong. They do not look at as whether we should get involved, whether there was patent illegality. They look at athletes also while looking at the federation. So I think the result would have been very much different if there was a Court of Arbitration Sports where the prominent sporting personalities would have been presiding over it, or even someone with more sporting experience was presiding over it. In general, the courts could have opined for a fair trial, and the key to conducting it at the right time, so that the situation did not take place in future. So the sabotage defense with not enough evidence that helped Yadav secure a clean sheet before NADA and was not enough to help him before CAS. This highlights the incompetence and inefficiency of the top anti-doping agency of our country as well. India lost Sushil Kumar and Narsingh Yadav. Basically, India was the only loser in this case, because they did not have someone competing for an event where they were successful twice in the two prior events. And these conclusions just point towards the direction of adopting global standards of dispute resolution in sports, or acknowledging CAS as an adjudicating authority, that as well as federations could approach the global authority for faster and authoritative review. There was another PI by Rajiv Datta. He's the senior advocate of Delhi High Court. He asked for a writ of mandamus to be issued against Union of India to consider CAS as a genuine dispute settlement authority against the order of national sporting federations and international sporting federations. So Union of India went and said international sporting federations already have CAS as a genuine dispute settlement authority. It's just the NSFs, national sporting federations, and even for them, we have brought in a code which is still in development, but that suggests that CAS would be a dispute settlement option. But the brief facts of the case were that Devi was banned by the AIBA for breaching AIBA disciplinary code by refusing to accept bronze medal at the Asian Games. However, she was unable to file an appeal against the CAS as the relevant national sporting federation, being Boxing India, failed to provide for such a right within its regulations. So she could not go ahead and fight her disciplinary action which was taken against her, because the Boxing India did not in its constitution have a procedural norm of raising your disputes to the CAS. Unfortunately, however, many NSFs in India still not have included such a provision, even after the court suggests, and leaving their athletes stranded without having a recourse to appeal to CAS. So what needs to be fixed for the development of sports and sports law in India? A national codified law is must, which would ensure proper structure and liabilities of the sports bodies, key policies for sports bodies, including code of conduct, policies for discipline, selection harassment, sexual harassment, conflicts of interest, recruitment, and awards. They have failed to implement the national sports policy even after repeated attempts. So this needs to be fixed first. It is apparent from the guidelines that NSFs must establish appropriate international mechanisms to resolve disputes in a coherent manner based on the written guidelines in their constitution. The guidelines mandate all NSFs to create rules addressing the said issue. One significant problem in the Indian sports today relates to dispute resolution, and especially dispute resolution within the National Sports Federation. So, like I said, some rules and some NSFs have specified rules and regulations for first instance dispute also, but most of the NSFs have not specified such rules. Some NSFs have a first appellate authority, but again, most of the NSFs do not have a first appellate authority. So that problem also needs to be fixed in general, and that would develop the sports and the sporting industry in general in India. The recognition of CAS as an adjudicating authority would help all the stakeholders, even the sports lawyers, for example. A lot of work would come into picture, and I think it's athletes would get a faster remedy, a better remedy, and that's why CAS should be an adjudicating authority, and it should be in the picture. The establishment of Indian CAS on the international model could help in resolving disputes in a speedy manner. It is important to note that athletes' career is again very short, and litigation through normal process are prolonged. So, for the betterment of athletes, it would be best to have an Indian Court of Arbitration of Sports also, as they have suggested time and again. But it needs to be implemented. The implementation has been lacking for a while now, and for the development, and if they really want to achieve the objective of securing more gold medals like the smaller nations achieve, and their tally is better than India, then it has to be done. There's no uniformity in functioning of two different NSFs. Every NSF has been making and acting on rules despite court orders and regulations. One way to fix the problem would be acting on the suggestion in 2001 and bringing sports within the concurrent list. So once they bring in sports within the concurrent list, it will automatically solve a lot of disputes and a lot of litigation that has been revolving around the National Sports Policy and National Sports Development Code. And the Union of India would automatically become one of the legislators on such topic, and there would be no frivolous litigation. And it's clear that they want to manage it. So why not bring it within the concurrent list, and why still let it remain in the state list? I do not get that also. At the same time, it would be important for the Union of India not to overlap and micromanage the sporting federations. Otherwise, it could lead to a situation just like when in the Indian International Olympics Committee banned the Indian Olympics Association for the reasons of government interference. So again, another thing that I want to point out is how the overlap has to be stopped. And just like in the case of BCCI, they let BCCI make their own rules. The BCCI decided not to comply to NADA. I think the NSFs do need that autonomy that has been there, but at the basic regulations, basic functioning, the acknowledgement of CAS, the bringing in of the Indian Court of Arbitration Sports would help develop the field, would help develop the sports and the sporting federations, and would in general make the whole industry flourish in a much better scenario. So I believe I've covered the major Indian context with my presentation, and that would be.
Thank you so much, Mr. Vedant Agrawal, for this elaborate presentation. And to sum it all up, Mr. Agrawal, and correct me if I'm wrong, so there's not much jurisprudence that has developed when it comes to sports law. And number two, I think even the court intervention has not been that much to the extent that we would have required to. Number three, there are problems like match fixing, betting, which had plagued the Indian cricket system and administration.
So
now the time has come when there is a central legislation or there's a codified governing law that governs sports. Because I personally feel that if you want sports and sports persons to flourish in our country, if you want to bring out the best from them, then we need a central legislation. We need a codified law for that purpose.
Definitely, the codified law is the first thing that has to be done so that the whole functioning can get better. And as far as match fixing is concerned, so like the Loda committee reported, the betting has to be legalized, and once that sector is legalized, I think the match fixing element would go away, because what people want actually is a source of entertainment. Like in the case of Dream 11 and other apps, it has already been happening, and they have already made a fantasy sports world real, which involves monetary aspect also. So if they legalize sports betting, I think it would automatically make the picture in terms of sports fixing and betting illegal betting much better.
And also, there's much.
But
There are a couple of disputes also or issues that are pending before the Honorable Supreme Court with respect to, I think, the game of skill or the game of chance. As far as betting is also.
Yes, so it came with poker, judgment on poker especially.
Yeah.
It came around whether it is a game of skill or it is a game of chance. They opined that it is a game of skill because it needs calculations, and it includes calculations as an aspect to the game. But if you consider Teen Pati, for example, the other edition of it, or the Indian poker as we call it, that is completely by chance because you do not calculate the cards, you're not even looking at the cards. So that is the argument that came into the picture.
Well, thank you so much, Mr. Agrawal, for this, for all the time for all the energy and effort that you put in for this lovely presentation. And to all the viewers, in case if you still have a doubt or a query with respect to any particular fundamental or any particular concept that is still bothering you, feel free to write to us, and we'll be more than happy to forward the same to our speaker for today's session, the amicus for today's session.
Definitely.
We would love to help you solve all your queries. And after all, I think every problem needs a solution, and we need to figure out how. So that is important, and that is the only way to solve it, and not by avoiding it.
Definitely.
So thank you so much, Mr. Agrawal, once again. And
my pleasure.
So much, everybody. Stay tuned. Next episode is on its way, and please like, subscribe, and share my channel. And please stay home. Please stay indoors. Please take good care of yourselves. The pandemic is here to stay at least for some time, and take care of your loved ones. And keep watching the virtual amicus. And signing off from here. Thank you, Mr. Agrawal, once again. See you soon.
Thank you.
Thank you. Bye.